and hear me, I hope. Thank you. Yeah, it was a bold move, but I thought rather than running the risk of it being disconnected sometime, just losing the whole thing altogether, I might as well try to start again. That's very good. Right. Obviously, I'm still hoping that many of you will participate in class, and we can have some interaction. Right. Where we left before Christmas was looking at the relationship of the Chief Executive and the Legislative Council, how their powers and functions actually present a situation of check and balance, or mutual regulation, or coordination, depending on how you look at it and what your standpoint is. The provisions are there in the basic law, and for our purpose, of course, you will have to be familiar with all the provisions or the articles that I have been referring to in class. And if you were asked any question as to who is more powerful, or who actually has the ultimate power to do this and to do that, then you obviously will have to make reference to the articles and then go through your analysis process and then reach your own conclusion, right? And here we are onto the election system. It is provided, of course, in the basic law that both for the Chief Executive and the Legislative Council, the ultimate aim is to have universal suffrage, whatever that means, and that based on the principle of gradual progress, and in light of the actual actual circumstance, situation in Hong Kong. So the phrase is in light of the actual situation, and in accordance with the principle of gradual and orderly progress. One thing is clear is, as far as the Legislative Council is concerned, and also, of course, Chief Executive, what the basic law has provided as far as the election is concerned is yet to reach universal suffrage. And the particular provision, of course, is Article 68. Article 68. There have been on a couple of occasions when attempts have been made to introduce progress to the election system. So far, the more significant change was the introduction of a special category of functional constituency, and that is the District Council's District Council 2 seat, 5 of them. The electorate being all Hong Kong registered electorates who do not belong to any other functional constituencies. Let's look at this sort of from a very basic And first of all, the basic, I would always like to start from the Joint Declaration, because that is where the system, or the, if you like, the creation of the system would be put in the proper historical context. Although some hold the view that the JD is no longer relevant. It might be when we are looking at it from a legal point of view, but constitutionally, we really have to go back to where it started. And of course, as far as Hong Kong is concerned, where it started conveniently, maybe 1842, or even without that, even if we didn't want to, we want to be more pragmatic. I think one cannot simply say, well, let's start with the Basic Law, or the enactment of the Basic Law, 1990, April 1990. That would be ignoring some fundamentals. So let's go back to Joint Declaration. And in the Joint Declaration, there is no mention of universal suffrage. And in relation to the CE, it only says that the CE can be chosen by way of election or through consultation. So that, it's clearly optional as far as election is concerned. But of course, we have since day one, since 97, with the enactment of the CE election ordinance, is accepted by all stakeholders that CE is to be elected, and of course subject to the Basic Law, under which it is for the Central People's Government to appoint the CE. As far as LegCo is concerned, in the Joint Declarations, it does say to be constituted by elections, but it didn't say what type of elections. Well, you may ask, how many types? Well, many, right? For example, where you must have heard the description, small circle elections. Well, that maybe it could be taken as the contradistinction against universal suffrage. Not big circle. We're not talking about circle, but everybody, right? One should actually, at this point, also understand the thinking behind those in power on the mainland. As far as the socialist system is concerned, or indeed, if you go as far back as Karl Marx, they're always skeptical, if not suspicious, of elections. You may have heard, and so often, that from people who are more subscribed to the socialist system, describing the Western style of election as a sort of deception on the electorate, the general mass. It is been described as a means of deceiving the working class or the peasants by syndicates, by power syndicates. Of course, from the modern democratic society's point of view, we are focusing on the right to participate or to take part in public life. Now, this is a right given, provided by the International Covenant on Civil and Political Rights. So we should have this again at the back of our mind, and do try to understand the political culture of those in power on the mainland, and what Hong Kong have been exposed to, if not before, at least since 1976, when UK extended the ICCPR to Hong Kong as one of its colonies. So when the Basic Law was drafted, the focus was really in devising, to start as a starting point, a small circle or small circle elections. You will see there are not only the continuation of functional constituencies. Functional constituencies, by the way, is not a new thing. Of course, you will know, indeed, in Hong Kong, in the colonial days, it was not until 1985 when there was indirect election, which in a lot of ways is the predecessor of the functional constituencies. 1985, you see. Before then, LegCo members, if they are not public officials or government officials, they would be those appointed by the governor to sit on the Legislative Council. And in the structure of the Basic Law, you will see that the respective methods of election in relation to, first of all, the Chief Executive, and secondly, the Legislative Council members, they are contained in Annexes 1 and 2. 1 being for the CE and 2 being for LegCo. As far as CE is concerned, if you turn to when you turn to Annex 1, you will see that initially, for the first CE, the election is done by an election committee comprising 800 members, and these members are from 4 main sectors, and they are respectively the industrial, commercial, and financial sectors, 200 of them. Secondly, another 200 from the professions, and the third group, another 200 from labor, social services, religious, and other sectors. And then the remaining 200 are from the, if you like, the political sector, and they are the members of Legislative Council, representative of district-based organizations, Hong Kong deputies to the National People's Congress, representatives of Hong Kong members of the National Committee of the Chinese People's Political Consultative Conference, altogether 200 of them. And their term of office is 5 years. Right. And this election committee, their own election and the size of it is subject to amendment. And Section 7 of Annex 1 make reference to the year 2007. So that's Annex 1. The 800-member committee has now been expanded to 1,200. And there have been much discussion, in fact, in 2014, where there was general discussion, consultation on how this could be amended in order to implement Article 45, where it says, in light of the actual situation in Hong Kong and in an orderly and progressive manner, where the election could be done by way of universal suffrage. Of course, it was a qualified universal suffrage because there would be a nominating committee which adopts a democratic procedure in coming up with a nomination or nominations. As far as the Legislative Council is concerned, half of LegCo was to be when it started, was chosen by a small functional constituencies, and also and this is where Annex 2 has made clear, and indeed it goes on to provide how the second and third terms of LegCo should be comprised of as far as the election is concerned. It goes on to say that the second term, if I can, the second term is, let me take you to the next, I was going to read you the annexes, but actually I have it on the slide. Now, first of all, this is the Annex 1. I just read it to you, and indeed, when back in August 2010, it was amended and approved to have it expanded to from 800 to 1,200. And I'm not going to repeat it because it's only the figures that were changed, not the actual distribution among the four big sectors. And then as far as the Legislative Council is concerned, when there was the last amendment was in 2010 August, it expanded the council, the number of members from 60, which was 30 and 30. 30 returned by functional constituencies and 30 returned by geographical constituencies through direct elections, from each of them from 30 under each to 35. That is what we have currently. Here is a graph which I think will give you a much better picture of the composition and the way that these members were elected for the various terms of LegCo. First of all, it's a matter of language. When I say members, how members were elected, it could you might have heard, and you sometimes hear people say returned, might have been returned. The word returned in this context could be used interchangeably with elected. And you will see that for the period of 1995 to 2000. Now we have to look at the asterisk there. It says including a 60-member provisional LegCo which operated between 1997 to 1998. Provisional LegCo is a body that was not created by the Basic Law. It's something outside of the Basic Law, and it was brought into our system out of necessity. Does anybody remember why? Why was it necessary? The government was changed. Okay. Could you be more specific? Wu Jiayi, could you be more specific? I think you probably was thinking along the right line, right track, but what actually did you mean by government was changed? Well, that is definitely the case, and of course we know by now it is the important date of July the 1st, 1997, when the British government, or UK for that matter, left Hong Kong back into the governance of the PRC, and that was what was agreed. That's what was agreed in the Joint Declaration. And when one goes to the Basic Law, remember when we look at LegCo's terms of office, the term of office of Legislative Council is 4 years. Each term is 4 years. But for the first term, it is only 2 years. The first term of LegCo was anticipated it should run from 1st of July 1997 for 2 years. However, that did not happen. Why was that? Just for transitional handover. As I said, provisional LegCo is not something that you find in the Basic Law. the transitional arrangements, rather, indeed started right after the joint declaration was signed, and with the establishment of a joint liaison group. That joint liaison group comprised representatives from the two governments, right? So, and indeed, what is on the agenda of the joint liaison group was what was then called a through train model. A through train arrangement for electoral members. The last election, or electoral election, that's correct, Simon. It's the 直通車, and the last electoral election in the colonial days of Hong Kong took place in 1995, and their term of office of course, at most will be up to 30th June 1997. Now, if you look at the decision of the National People's Congress, which is at the back of your version of the Basic Law, which entitles Decision of the National People's Congress on the method for the formation of the first government and the first Legislative Council of the Hong Kong Special Administrative Region. And in here, it made specific provision that the first Legislative Council of Hong Kong SAR shall be composed of 60 members, with 20 members returned by geographical constituencies through direct elections, 10 members returned by an election committee, and 30 members returned by functional constituencies. If the composition of the last Hong Kong Legislative Council before the establishment of the Hong Kong Special Administrative Region is in conformity with the relevant provisions of this decision and the Basic Law of Hong Kong Special Administrative Region, those of its members who uphold the Basic Law of the Hong Kong Special Administrative Region of the People's Republic of China and pledge allegiance to the Hong Kong Special Administrative Region of the People's Republic of China, and who meet the requirements set forth in the Basic Law of the region, may, upon confirmation by the Preparatory Committee, become members of the Legislative Council of the region. And the term of office of these members of the first Legislative Council shall be 2 years. Instead of the normal 4 years, it shall be 2. So in brief terms, it means that those members who were elected to the 1995 Legislative Council during the colonial days may become members of the first LegCo for 2 years if they uphold the Basic Law, if they swear allegiance to Hong Kong SAR of PRC, and if they meet requirements of the Basic Law, and if they are confirmed by the Preparatory Committee, which is a working body under the National People's Congress Standing Committee for the establishment of the Hong Kong SAR. So with all these conditions, if they were being met, these members from the 1995 Hong Kong LegCo may become members of Hong Kong SAR LegCo from 97 to 99. It didn't work because, and that was my question, why? It wasn't because that they needed a transitional handover or not enough members. It was there because of the allegation, or the view taken by PRC that Patton, the last governor of Hong Kong, had introduced and implemented an electoral system for the 1995 legislature that did not conform with the Basic Law, that was in contravention with the Basic Law, that was also contrary to agreements that had been entered into at the joint liaison group between representatives of the two governments. And on that basis, because of that, the Standing Committee of the NPC, through a decision that they made, established a provisional LegCo to cover the period of July the 1st until July 1st, 1997 to June 30th, 1998. And with the principle or the main task to put in place legislative measures that were necessary for the establishment of the Hong Kong SAR under the Basic Law. So that was the background and what had led to the establishment of the Provisional LegCo. Members of the Provisional LegCo were elected at the end of 1996, and they started operation in around February 1997. Of course, all geared up in preparation for the establishment of the new government. Do you know where they operate, the Provisional LegCo, during the time of before the 1st of July 1997? Yes, that's right. They operate from a private building. That's right. Is it? I'm not sure the name of the hotel, Fulin Hotel. I'm not sure about that, but it was not in a government building, but in a private building, a hotel, which has conferencing facilities for them. So that was, and they operate. Oh, you saw the meeting room, right? Yes, and at some stage, at some point in time, there were members of the Provisional Legislature who were at the same time members of the Legislative Council of the Hong Kong, of the colonial Hong Kong. So it was quite an arrangement and physically demanding for some of those members who actually were wearing two hats at the same time. During that time, there have been views taken that the Provisional Legislature was not a lawful institution because it was not a body established by the Basic Law. However, that has been that issue have been settled by Hong Kong courts in a couple of decisions made after 1997. Okay. So, any question on this Provisional Legislature and the history and also of the elections, and also anything from this diagram, from this chart that you wish to ask? And from here, of course, you can see that for the purpose of election, the system has basically has been the same system since, if you take it as, you can take it as far back as 1985. Of course, in 1985 was colonial days, and we were talking about indirect election and also appointed members. 1995, one of the points taken was among the functional constituencies that Patton established in his model was to cater for everybody, for everybody in Hong Kong who does not belong to any established functional constituencies, and that becomes a very big group that includes unemployed people who do not, who are retired, who do not have an occupation, employment, and including houseminders, or if you like, housewives, and so on, which effectively turn the functional constituency into another geographical constituency, or another constituency that comprises everybody. So everybody then has two votes. One vote in the geographical constituency, that is briefly where you live, and the other vote is the occupational group that you belong, or the chambers of commerce that you belong. That is not the idea behind the elections. I mean, mainland authorities, the Chinese government, was not ready to have such kind of election. Remember the provision in Article 45 and 68 in relation to election of CE and LegCo, where it was talking about making progress in accordance with the actual situation in Hong Kong, in accordance with or in light of the actual situation, and in accordance with the principle of orderly and progressive development. So that was not accepted, and then that was considered as a breach, and that's why it then derailed the through train arrangement. It derailed the through train arrangement, and that was what happened. All right. Let me just elaborate a little bit on geographic constituencies. It is more like, just bring you back to what you already know, I hope. And as far as the current LegCo is concerned, there are 5 geographical constituencies: Hong Kong Island, Kowloon West, Kowloon East, New Territories West, New Territories East. The small numbers are signify the number of seats, and the number of seats was calculated based on the size of the population in a particular physical area, and the delineation of these boundaries is a function given to the Electoral Affairs Commission, which is not part of government, and chaired by a serving judge, High Court judge, and that commission is performing or indeed handling or responsible for all the election matters independently. Functional constituencies, I don't know whether it's clear or not, whether you can see it. Can you see? I thought there's somewhere maximize. Let me see. Okay, can you see this? I hope you can. I'm not going to go through each and every one of them, but I hope you will be able to see that the idea was to cover the major professions and occupation in Hong Kong, and also the important bodies which contributes directly to the economy of Hong Kong, and these are the Chambers of Commerce and the import and export sectors and so on. One particular group is the Heung Yi Kuk. Heung Yi Kuk itself is a representative body established by ordinance, which has been identified as the consultative group that the government will go to on the New Territories affairs. It has command a very special and sometimes privileged position in the history of Hong Kong, and especially if you go to when you go to Article 40, you see that a specific provision has been made for protecting the rights and interests of indigenous inhabitants of the new territories. Article 40 provides as follows. It says, the lawful traditional rights and interests of the indigenous inhabitants of the new territories shall be protected by the Hong Kong Special Administrative Region. So it is a provision which expressly made for protecting those indigenous inhabitants of the new territories. What is indigenous inhabitants? Do you know? Indigenous inhabitants. Indigenous. Do we have an indigenous inhabitant of new territories here among us? Yes. 原居民,原住民. Yeah. And how do we define it? Who? I don't know. Is that how they call? Why hug? Yeah. Okay. I don't think color matters here. The 5 big surnames. Right, yeah. Good. The Man, the Tang, the Lao, quite a few others, you're quite right. Yeah. People living in NT and born in Hong Kong before 1997. Well, we are talking about ancestry connection. They have to have ancestors live in the And one of the rights that's been talked a lot, is about the small house policy. There's a case before the court, still under appeal, I believe, on the lawfulness of small house policy. But that is a little bit as well. I mean, we haven't reached that yet. We'll be looking at judicial review later on. But at this point in time, what I would like you to focus is on these functional constituencies. It was said at one stage by government that these functional constituencies are to cater for people who are in certain profession and who are prepared to offer themselves in the public service, but at the same time are not interested in taking part in elections, and therefore, or general elections. Therefore, some special arrangements were made in order to allow them, or in order to find them the opportunity to serve on a legislative council. And initially, these were the lawyers, the medical doctors, the accountants, and also representatives from the chambers of commerce, and from labor unions. Then that gets expanded to cover other industries and so on. I think the same rationale apply even today for the continuation of functional constituency. Whether their continual existence will meet the requirement that eventually, ultimately, the election should be of universal suffrage, i.e. the short question is whether having functional constituencies is an arrangement that universal suffrage does not allow. Well, there have been different views held on this, and of course, in the development of the electoral system for LegCo, we haven't reached that point yet, because according to the decision of the Senate Committee of National People's Congress, it is after the CE, after universal suffrage is introduced to the CE election, that LegCo selection, we can have universal suffrage for LegCo election. Let me see. People claim they have rights to occupy these lands, so-called new territories. No, I don't think so. New territories is just a translation, and then generally it referred to the piece of land north of Boundary Street, and was leased to the UK government under a different treaty, under a different arrangement. An arrangement different from the cessation of Hong Kong and the Kowloon Peninsula to UK. So nothing to do about the right to occupy. Right, so that's the functional constituency. And the next slide I want to show you is a slide which will generate again a lot of discussions recent months in relation to the qualification for becoming a candidate in LegCo election. First of all, at the sort of composition level, at the level of on the question of personal qualification, under Article 67, there shall be at least 80% of the members of LegCo who must be Chinese nationals with no right of abode overseas. The restriction is imposed by way of or expressed by way of excuse me, of percentage, by way of percentage. It reads as follows: LegCo shall composed of Chinese citizens who are permanent residents of Hong Kong SAR with no right of abode in any foreign country. However, permanent residents of the region who are not of Chinese nationality or who have the right of abode in foreign countries may also be elected members of the Legislative Council of the region, provided that the proportion of such members does not exceed 20% of the total membership of the council. So what is on the slide is just another way of expressing the same thing. At least 80% have to be Chinese nationals with no right to vote overseas. And how these not more than 20% is allocated under the current law, under the existing law, which is Legislative Council Ordinance, you will find that these seats, rather, they are actually allocated to the functional constituencies, 12 of them, under Section 37 of Legislative Ordinance, where it is provided expressly foreigners, in short, can be a candidate. However, one thing in common and one thing which applies to all is that before they're elected, they obviously have to become a candidate, and in order to be a candidate, they have to sign a declaration to uphold the basic law, and that is in accordance with Section 40 of the Legislative Council Ordinance. And this is where the prospective candidate has to sign a declaration, make a written promise that he or she will uphold the basic law, And under Article 104 of the Basic Law, when they take office, when assuming office, they have to swear that they will uphold the basic law and swear allegiance to Hong Kong SAR of PRC. Of course, for anybody to sign a declaration, common sense tells us that it has to be true. It has to reflect your true intention. If you were not able to hold such true intention, then such declaration cannot have effect. And if such declaration cannot have effect, then whoever signs it, intending to be a candidate running for a local election, will not be able to qualify to becoming a candidate. Who decides that? Under the law, under the ordinance, it is for the returning officer to decide. The returning officer, under the law, there's no provision which spell out the qualification of a returning officer. Who can be a returning officer is not provided expressly. And as a matter of arrangement, it is generally a fairly senior civil servant who is either a commissioner at the district, not commissioner, but a district officer at a certain district, which by way of ranking, it will be a directorate rank civil servant. Directorate, do you understand the term directorate? Directorate? That's correct. uh, and in recent years, we have seen cases, court cases, in which an intended candidate had been disqualified by a returning officer on the ground that the declaration required to be made under the electoral ordinance was not true, and therefore does not meet the requirement of the ordinance. This slide shows among those who have been disqualified, one of those who is this person is one of those who have been disqualified, and where the returning officers say that they were not genuine in agreeing to uphold the basic law. The courts had decided that the power rests with the returning officer, and of course it's a matter of statutory duty which has to be performed in good faith, and also has to meet all the usual standards required under public law or in administrative law, including rules of natural justice. A recent case under which the returning officer's decision to disqualify was quashed because the person concerned was not given a reasonable opportunity to make representation on the intended decision that the returning officer was going to make. That was considered as not acceptable and rendered the decision unlawful and void of no effect. That's procedural justice, right? Under natural justice concept. The requirement to make such declaration and also the undertaking that if elected and when assuming office, a electoral member elect has to take an oath of office in accordance with the law. And the law so required, with such requirement, is in the basic law is Article 104, and the ordinance is the Oaths and Declarations Ordinance, Chapter 11, Laws of Hong Kong. Article 104 of Hong Kong Basic Law is not tailor-made only for electoral members, but all the top government officials, the judges as well, all have to take oath to uphold the basic law. It was in the October 2016 when a few of the members, in fact, in total, 6 of the electoral members were taken to court by the government because of the manner they took the electoral oath when assuming office. It was considered that the manner of taking oath was tantamount to neglect or decline to take the oath, and therefore not taking the oath lawfully. And you can see we say failing to take oath properly. There were two among them who were taken to court first, and they were Sixtus Leung and who was the other one? Suddenly. Who was the other girl's name? It will come back. Right. That case was taken to court in the name of the Chief Executive and the Secretary for Justice. Both is a judicial review application and also the seeking of an injunction against the members. Yeah, because the president of LegCo at the time was or had decided to allow Sixtus Leung and Yao Weijing to retake the oath that they took, or they had purportedly took. And government took the view that there could only be one chance for taking the oath properly. If the member-elect has failed to take the oath in accordance with law, then under the law, under both the Basic Law and the Oaths and Declarations Ordinance, they will have to vacate office immediately. And on that logic, once they have vacated office, then they will not be qualified to take the oath the second time, according to them, because they would have lost their status or capacity as a member-elect. So, and because of that, government is also seeking an injunction against the member himself and herself. So it was one of those very few cases where government actually, if you like, sues the president of LegCo. At the end, do you know the result of the case? Remember the result of that case? The result of that case, do you remember? Do you remember the result of that case? They were DQ'd. Yeah, that's the abbreviation. They were DQ'd, disqualified. Of course, in law, it wasn't a disqualification exercise. Right? In law, it was for the court to consider the lawfulness or otherwise of the decision of the President of LegCo, one, under the judicial review proceeding, and the other under the Legislative Council ordinance, whether the court ought to forbid the two person to continue acting in the capacity of a Legislative Council member. The court decided in favor of government, and the two Sisters Leung Zhonghang and Yao Weijing, they were first of all enjoined or forbidden to continue acting as LegCo member, and it was also declared that the President of LegCo his decision was unlawful. There was no lawful basis because they had already failed to take the oath. And one thing which happened before the case in court was concluded, and that had drawn had generated a lot of public discussions, and that was on bullet point 3, third point. The Standing Committee of the National People's Congress handed down an interpretation of Article 104 of the Hong Kong Basic Law. It's a fairly long interpretation. The relevant part here, the directly relevant part here is that it made explicitly that whoever or among those who are governed by Article 104, i.e. the Chief Executive, the judges, the senior civil servants, and so on, the public officers, they had to accurately, completely, and solemnly read out the oath. So that is the requirement of content, form, and attitude. And Sisters Leung and Yao Weijing, for those who remember what they did, objectively did not meet these requirements. Now this is an interpretation, so it is given in general terms. It was not directed at that particular case before the court. However, this interpretation came out before the decision of the court was made. So there was criticisms against the Standing Committee that the timing was bad because it gave the impression that the Standing Committee was intending to interfere or influence the judge who was determining the applications made by government. In that judgment, the judge had said that even if there wasn't the interpretation by the Standing Committee, he would have reached the same conclusion in accordance with common law principles. The fact is that back in 2012, I think it's 2004, Mr. Justice Hartman, in dealing with the case launched by Leung Kwok-hong, had already spelled out the requirements under common law for taking an oath of office under the Oath and Declarations Ordinance. So there's nothing new, but the fact was, Standing Committee saw fit that such interpretation should be made at that time. Right, any questions on the taking of oath? Right, I saw that it's the 26 minutes past 8. Let's take a break, 15 minutes, and let's come back at 20:40. Yeah, I'm just taking a break now. Good for you. So how are you doing?
I'm
Right, we are back. So we've dealt with the in the last minute. Okay, well, I know that the assignment has been uploaded to Seoul, and you will have by now seen the question. Now, what let me finish this part on the election first. And before I start with judiciary, we'll spend a little bit of time on the assignment. Shall we? Now, I was going to ask you, do you have any questions on what I've said about the taking of oath of office? I've made reference to the case of Citis Leung and Yao Weijing. That case went all the way to Court of Final Appeal, but with the appeal committee of the Court of Appeal not giving leave for it to be heard before the full Court of Appeal, Court of Final Appeal. So, and in the meantime, government took 4 other legislative members to court, and they include Leung Kok-hong, Luo Gun-chong, Yao Xiaolai, Lau Xiaolai, and there was the architect, the Yim something, right? The 4 of them, and they all lost their case, and also their legislative member status. And as a result, some by-election was done, and so not all of them result in by-election, some didn't. So that was the taking of legislative oath. Right. Let's move on to looking at a little bit more about functional constituency. I told you about the rationale of introducing such constituency back in the colonial days, and with the peaking under the basic law, there are also these functional constituencies, but the emphasis was more about equal participation and the to enable various interests in this among the various sectors in society to be taken care of. So this is in Chinese is the 均衡参与, the equal participation. So there is half of the legislature, now 35 seats, that are allocated to the functional constituencies. Most of these constituencies are small, are very small, some only up to a few hundreds, one of which I think the smallest one is the fishery, and of course when you look at Heung-yi-gok, that is very small, right? And some of which also and the right to vote and stand for election is limited to a small number of voters, therefore, right? Just a few tens of thousands. But of course, this is not taking into account, not including the District Council number 2 functional constituency. For that one, where initially under the District Council number 1, only the few hundreds, 400 something District Council members were elected. But for that, the other one, we're talking about basically everybody who hitherto before did not belong to any other functional constituencies. Some have very small seats and they use corporate voting, so which is one company, one vote instead of individual voting. So you like transport, for example, or some of the chambers of commerce, and some is a mixed system where individuals can vote and corporates can vote. So the basic law has not provided in detail how these functional constituencies should be devised. What it says is just in general principle that the Hong Kong SAR is empowered to set out the limitations of these functional sectors and so on. So basically, this is all given to the SAR is given a wide power to devise this. And so the next slide is to again make it more explicit, or for you to remember that size is not an issue. It's not a matter of size, Previously, we were talking about 小圈子 and so on, but here it's not that. It is. It can be big. It can be small. As I said to you about Chris Patton before '97, at the last election, he also have created some very, very big functional constituencies. It's basically basically is a matter of political will. It's a matter of policy. So for the District Council second functional constituency, there were 3.2 million voters who elect 5 of the legislators. And so often they are called super seats because of the large size, and everyone who cannot vote in a small FC can now vote in a super seat. So everyone has 2 votes now, one in the FC and one in a geographical constituency. My next slide is to demonstrate to you the various sizes, and you will see that the finance sector, these are the bankers, and only 125, insurance 130, Hungry Cook 145, agriculture and fishery again under 200, transport a lot of mainly corporate voters 200 something, and then you can see others. The lawyers have a larger one, 6,400, and indeed you will see from here. You will notice the number of registered voters is not even half, not quite half of the qualified lawyers. Right, the registration rate is pretty low. Next is a serious question. What is universal suffrage? We have, at the beginning of the establishment of the Hong Kong SAR, small circle elections, both in relation to the Chief Executive in Annex 1 and Annex 2 in relation to the Legislative Council. it was set out in clear terms under Article 45 in relation to the Chief Executive and Article 68 in relation to Legislative Council that the election will eventually be universal suffrage, ultimate aim, it says. But no date been set for when this ultimate aim will be achieved, will be reached. In the 2007 decision made by the NBC Standing Committee, it says it's possible in 2017. That's exactly what what Annex 1 provides. It is by 2017 amendments could be made, and according to Annex 1, as long as once it's made, then what needs to be done is for that change to be sent to NBC Standing Committee for approval. And in relation to the legislative change, the change to legislative election, it only needs to be submitted to Standing Committee for the record. For the CE election, as I had said when we were looking at Article 45, that universal suffrage is to be preceded by a nomination procedure undertaken by a committee, which follows a process which is described as a democratic procedure. Right? There shall be a nominating committee who undertake this democratic procedure in making nominations. Right. So the framework was quite clear, and that was when the Basic Law was enacted in 1990. And it was contemplated that within 10 years, or in 10 years' time, there could be a change to the election methods, and with the ultimate aim that there shall be universal suffrage. However, this original intention, in a way, was changed by an NPC Standing Committee interpretation in 2004. Now, first of all, when I make reference to Annex 1, there is a reference to a simple procedure for amending the election method, so that we could have universal suffrage for CE, and similarly for LegCo. And as far as the CE's elections change to CE's elections concerned, what needs to be done is submission for the Standing Committee to approve. And the exact wording is this. It says, if there's a need to amend subsequent to year 2007, such amendments must be made with the endorsement of a 2/3 majority of all the members of LegCo and the consent of the Chief Executive, and they shall be reported to the Standing Committee of the National People's Congress for approval. In relation to LegCo, similarly, it says that again, this change, the election method can be changed after 2007, and then again with the similar requirement of 2/3 of LegCo members and consent of CE, all that could be submitted to Standing Committee for the record. So all seem pretty well designed, and it's just a matter of time. However, 2004, the Standing Committee made an interpretation and had created what some people have said the 5-stage process for universal suffrage. How? Well, first of all, the Standing Committee's interpretation says, when it says in Annex 2 about the original text of Annex 2, this is in relation to legislature, when it says no need for approval, but indeed there should be approval at the end of the process, because at the end of the day it is for Standing Committee to interpret, and the result of the interpretation in 2004 is such that it has expanded its power to require their approval or its approval for starting the process. So what is set out in Annexes 1 and 2 is the end process for approval and for the record, respectively. However, the start of the process is different. Now, this interpretation, we're going to look at the detail more, but from the last bullet point on this page, you will see that it was considered as an example of the Standing Committee reducing Hong Kong's high degree of autonomy. For many people, they had thought that Hong Kong Special Administrative Region was given a free hand in deciding how to change the election method, both in terms of timing and the actual change, as long as these changes take place after the year 2007. However, with the interpretation given in 2004, it has the following effect. One, it's changed to a so-called 5-stage process. One, the CEA makes a report to the Standing Committee. This is new, something not in the basic law. Second stage, the Standing Committee decides if there is a need to make change, and also make rules on what kind of change are allowed. Then, this change will need the support of 2/3 of legislators and also the consent of CEA. It is only when all the above 4 steps have been taken and fulfilled, then the report to NSCSC for approval or for the record, respectively Annex 1 and 2, will kick in. So that's the effect of the interpretation. And the first time that was gone through was in 2014 to 15. Whereas when C.Y. Leung was the CE, he made a report in July 2014, and in August, the Standing Committee set the rules for introducing universal suffrage. Then it generated a lot of discussion in Hong Kong, and eventually The motion to change was moved by CE in Legco for the purpose of seeking two-thirds support, two-thirds of the legislative support, but it did not. It didn't. You see, the vote count was then 37 of them present, and there were only 8 who agree and 28 who didn't agree. So the motion to change was defeated, did not reach. And politically, many would have thought that those legislators who support the government would have given the necessary support, and the two-thirds majority could well be secured. But as it turned out, it didn't. And indeed, because at that particular point when vote was being called, many of the government supporters were not at the Legislative Council chambers, and that's why the number of members present was just over half of the full membership of 70. So from this recent experience, one can see how the central authorities, and in particular the Standing Committee of the National People's Congress, see their role and the extent of its power in deciding the political structure of the Hong Kong SAR, despite the express provisions in the Basic Law. Is a reflection, some say, of the comprehensive control or comprehensive power that the central authorities have in the governance of Hong Kong SAR, to the extent that it is for the Standing Committee to set rules for introducing universal suffrage. But of course, when you look at it closer, it is not something that whatever Standing Committee wishes to have will have, because under Annex 1, you still require the support of two-thirds of the legislators. And therefore you see that between 2005 and 2015, when there have been 3 attempts to change Annex 1, 2 failed and only 1 succeeded. And so far, what remains to be argued are the nomination rules. What does it mean by democratic procedure in Article 45? And functional constituency, whether their existence will meet the requirement of functional constituency, as demonstrated in my next 2 slides. Article 45 requires nomination by broadly representative nominating committee in accordance with democratic procedures. For those of you who remember, the public discussion then was quite polarized and also off the point, because there was very strong voice heard for demanding one man, one vote, and to cover not only the actual election but the nomination process. But such demand, from a legal point of view, is a non-starter, because the Basic Law has already provided for the nomination to be done by a nominating committee in accordance with democratic procedures. But that was not acceptable to many, and therefore the discussion did not really was not itself was not does not have the necessary ingredient for reaching any agreement or compromise. It's doomed to fail in a way. So that is what we the situation was. But politically, of course, that's another thing. But as a matter of law, when you go back to Article 45, demanding one man, one vote from beginning nomination to the end is something not even on the agenda. And there was also another point taken by the Standing Committee, which was thought difficult to accept, which was about the composition of the nominating committee in Article 45, whether there should be a body different from the election committee or otherwise. And the view taken then was it should be the same. And also restrictions imposed on the nomination of only 2 to 3 candidates. And the nomination must have the support of at least half of the nominating committee. Now that requirement, of course, naturally will reduce the number of candidates that may be nominated. So it left a big question. You may think it's not legal, but more political, and it's quite clear that China wants functional constituency to continue, and with the introduction of the district councils to functional constituency, whether the Chinese authorities were prepared to accept what is called quasi-universal suffrage is an interesting point. An interesting point there. And so left open now is, will Hong Kong ever have universal suffrage? Whatever that means. And the universal suffrage, some may take it as to mean very simply one man, one vote. Or are we talking about a regular election by electors whose votes carry more or less equal weight? We shall leave this to later, development. But as things stand, not until the CE selection satisfies the universal suffrage requirement, there will be no basis for changing the existing electoral rules for LegCo. So that brings me to the last slide of this session on Chapter 5. Any questions, please? Right. Now, I had said that I can set aside. Yes, Patrick, you got a question there? I saw that you were typing. let me turn up that assignment. I just wonder why I'm not able to download an assignment question. Let me see if I can save it to. Can I save it? Save it to desktop. I don't know why I can't find it. Okay, I'll do the screen, share my screen, right? I can share my screen, and that's right. Okay. Can you see that now? Can you see that? Good. Right. So you will see this in Seoul, which is assignment cover and question. Let me turn it into one-page format. Now, I think the cover is fairly self-explanatory. So what is important is you do not you are asked not to exceed the 2,000 word limit. All right. And then for submission, obviously you have to read the declaration and put your signature in and so on. Your assignment will be marked, and the question is here, and to be submitted by February 11th. Okay. So you have, Simon, you have helped those who can't see, on the screen, I think. So what are the main rules in Article 39(2) of the Hong Kong Basic Law that limit restrictions on human rights? Are there any other tests not mentioned in Article 39(2) which have been developed by the courts to limit restrictions on human rights? So we are yet to get to that part of our course. Human rights will be chapter 8, and before then we'll be looking at judicial review. This is a question taken from past exam papers. And where can I find Article 39(2)? Now, Article 39(2) of the Hong Kong Basic Law. So as long as you can find the Basic Law, right? And bracket 2 is actually, this is a common way of identifying Basic Law articles. They do not have the numbering system that we used to have in ordinances, but with articles that comprises more than one paragraph, the first paragraph will be the bracket 1, the second paragraph will be the bracket 2. So if I take you to Article 39, which I hope you will have in the material. So 39(1), for example. But let me deal with Honman's question first. Honman, do you now understand, or do you know how to find, or where to find Article 39(2) now? It actually means second paragraph of under Article 39, which reads, the rights and freedoms enjoyed by Hong Kong residents shall not be restricted unless as prescribed by law. Such restrictions shall not contravene the provisions of the preceding paragraph of this article. Are we all right there? Come on. Yeah, you just, yes, thanks, Simon. You just type out the provision of 39 bracket 2. You still cannot find second paragraph. I don't know why, but you can see, oh, now, can you see it? There are two paragraphs, Article 39. You got it? Let me take Michael's question now. It's all right? Iraq. Okay. Now, we are not, IRAC is the conventional approach more for answering problem type questions for the IRAC. For answering, however, it is good discipline to stick or to IRAC when analyzing the question. This, first of all, the question comprises two parts. The first part is self-explanatory when you read it, but as with other essay questions as well, our first job is to define the question, or to find out what exactly is being asked of us. That requires a very careful reading of the question or questions. When you go to 39.2, it is talking about rights and freedoms enjoyed by Hong Kong residents shall not be restricted unless as prescribed by law. So it has the effect of limiting restrictions on human rights. As we know, and I hope you will have covered this in your legal system, this is what we are reading is a law passed by the lawmaking body. What it actually means is a matter of interpretation. So we will have to read between the words and to find out whether there are rules as decided by court cases. Setting out principles that limit restrictions. So you have to go to the cases. The second part of the question asked, are there any other tests not mentioned? And then when we, and before we go to the second part, in the provision it says, unless as prescribed by law. So just a matter of reading the words, we know, it doesn't need a lawyer to understand this, but we know that restrictions, yes, you can have, but they must be prescribed by law. So it will involve an interpretation of the meaning that this phrase, prescribed by law, bears or carries. All right. Second, are there any other tests not mentioned in Article 39.2 which have been developed by the courts to limit restrictions on human rights? You see, this is prescribed by law. We will see from the cases what it actually means. It then goes on to say, asked you, in addition to this prescribed by law test, are there other tests which have the effect of limiting restrictions? And these, again, you will have to go back to the cases. Go to the cases. When I say go back, we haven't touched those cases yet, but you have to go to read those cases and identify from those cases what the restrictions are. So these two questions are very straightforward. These are questions of what. These are not questions of why. These are not questions of whether you agree or not agree. This is really straightforward. So IREX for this one may not be particularly useful, but it's good discipline, and indeed one of the aspects of adopting IREX is for making sure that there is a structure in your answer. For answering an essay question of this kind, you need a clear structure. You need this clear structure so that the marker or whatever reads your answer will follow your thinking. And the structure should be developed in a logical manner. And this also calls for a short conclusion, which summarizes the rules that you identified and the other tests that you identified. Are there any questions flowing from what I had said? You realize that I'm doing this, just giving you an idea of the approach. We will be looking at the subject when we get there. Let me see the timing. You see, our lectures will end on January the 14th. So you will have just about 3 weeks, just under 3 weeks to submit your essay, which is more than enough time. I think these questions are asked too soon. You will know what you have when you get there, and only because some of you are anxious to know, something about this. So I've taken the time to discuss with you if you like, the general approach. En passing, proportionality, yes, but let's wait until when we get there. If you are really interested, please go to read the case of Hyson. And if you really want to get it, it's not the 5 tests, it's 4 tests. If you really want to get up to date, most or a case that you may consider that you know well, I think, the facts well, is go to read this is about the anti-mass law. All right. You will see how the Court of Final Appeal analyzed the anti-mass law and decided that they met the constitutional test imposed by the Basic Law. Are we set? Are we all right there? it's good that you are taking a serious interest in the, understanding what the questions is. But only if you have time. Obviously, you can start doing some reading on it. The manual that you have has some very useful material, so as the cases that are extracted for your reading in the manual, right? So don't be too ambitious. Don't be too ambitious. So that's what I wanted to say. Give me some time to upload the PPT for chapter 6. I'm afraid it's taking a bit of time for uploading the PPT. We will be looking at the chapter, the Judiciary. This is an important chapter, which our focus will be on this, on understanding the role of the judiciary in Hong Kong, especially the concept of judicial independence as it is protected under the Hong Kong Basic Law. Then we moved on to looking at judicial review, and from there we'll see how a special category of judicial review, which we call constitutional review, is being developed, and the significance of this review, of this judicial review cases. The anti-marks law that I mentioned actually was also a constitutional review case, because it was looking at a complaint made by the 24 legislators who complained that, who alleged that the ordinance was in contravention with the Basic Law, because the chief executive had been given too general a legislative power which is so vague that it contravened the political structure established by the Basic Law, taking over the role of the Legislative Council. This complaint was accepted at the Court of First Instance by the two judges. However, it was overturned at the Court of Appeal level, and when it was considered, when it was looked at by the Court of Final Appeal, it decided that it did not contravene the Basic Law. So it's a constitutional review of the constitutionality of the Emergency Regulations Ordinance. Right. Can you see this, the role of the courts here? The PPTs, please confirm that you can see it. I'm going to take you through them. Oh, good. Thank you, Jia Yi. Usual reading, Articles 80 to 96 of the Hong Kong Basic Law, and Mr. Gitting's book, Chapter 6, and you can read some of these public speeches made by the Chief Justice. Indeed, also the more, in fact, is useful to go to the Judiciary website and pick up the many of the public speeches that the CJ has made, and you will see that he basically repeats the same subject, or sometimes in different words, and the same subject being independence of the judiciary. And that is, I think, he kept on emphasizing that, and the role of the judiciary. And in the context of the Hong Kong Basic Law, there is a lot of emphasis clearly put on continuity. And you can see the importance attached to the judicial system. The expression shall be maintained, is seen again in the Section 4 of the Basic Law, which relates to the judiciary particularly. And of course, shall be maintained is found in Article 8, which is the law previously enforced in Hong Kong, shall be maintained. And indeed in Article 5, which says that the socialist system and policies shall not be practiced in the Hong Kong SAR, and the previous capitalist system and way of life shall remain unchanged. So these provisions make very clearly that continuity is paramount. And indeed in the case laws, or in the case laws decided by the Hong Kong courts since the early days after 97, the Court of Appeal case, David Ma, also started. Actually, it was one of the very first cases which explained some of the fundamental principles underlying the Basic Law, and the theme of continuity was recognized, was given a judicial recognition, and that has become a very important tool and indeed an important purpose when interpreting statutes, adopting a purposive approach. And as far as the judiciary is concerned, the main change, and seems to be a change for the good or for the better, is the creation of the Court of Final Appeal, the creation of the Court of Final Appeal. Before 1997, cases in Hong Kong, the final appeal case, their final appeal was decided outside of Hong Kong. Where was it decided? Do you know? Do you know? The Privy Council in London. The Privy Council in London. That court, although we call it Privy Council, although we say it's a court, it is actually the Judicial Committee of the Privy Council. It takes cases from the Commonwealth and the colonies, and judges in Privy Council are judges from nowadays the Supreme Court, and previously, before the Supreme Court was established, it was the House of Lords judges who sits on the Privy Council. And this again given prominence, the final appeal, in Article 2 of the Basic Law, in the context of the high degree of autonomy given to Hong Kong. In addition to the executive and legislative powers, there is the independent judicial power, including that of final adjudication. Final adjudication is given to Court of Final Appeal under Article 82, and under the theme of continuity, courts in Hong Kong SAR will continue to have the same jurisdiction, same power. The only two restrictions, though, are explicitly acts of state, such as defense and foreign affairs, such as that about sovereign immunity, which was an issue in the Congo case. Congo case is the only case so far that the Court of Final Appeal had acted in accordance with Article 158(3) in submitting the case to the Standing Committee of the National People's Congress for an interpretation. We saw from the last slide that before 1997 there were cases that the courts do not have power to hear, and these are cases involving foreign diplomats or cases involving soldiers on duty. These restrictions will continue under Article 92. In addition to underlying or underscoring the importance of continuity, the Basic Law does not really go on to providing details on the role of courts, because as you see, Article 8, which preserves or which maintains the previous law, itself actually have the whole body of common law continuing, and that of course all these laws are embodied, all these decisions embody all the fundamental principles on the role of the courts. And that's why when we are discussing or when we are learning this subject, we will have to look outside the provisions of the Hong Kong Basic Law. We have to look beyond that. And we have in Chapter 6 given you an activity for you, which indeed is a reading of former Chief Justice Andrew Lee's speech in the context of the independence of judiciary, the way he described the role of the judges, so that and please do take time to read it and also complete the learning activity on page 69. Judicial independence. This is a concept that no legal system would disagree. It's so important that when judges perform their function, they should perform the function of adjudication independently without any interference. And it is only if that is secured that the judiciary can act as a check and balance on the executive and the legislature. And you can see that it is actually provided in Article 85 of the Hong Kong Basic Law, which says the courts of the Hong Kong SAR shall enjoy judicial power independently, free from any interference. Right? So that is the opening sentence. It follows on to say that members of the judiciary shall be immune from legal action in the performance of their judicial functions. Immunity is considered as an essential part of upholding or securing judicial independence, so that judges can act without fear. Of course, we are not saying that therefore they are not accountable. They do not take responsibility for what they have done, what they have decided. They are immune from legal actions, but all judgments are made to be open, delivered openly, and of course subject to public discussions. In the case of the Congo case, Mr. Justice Bukhari, permanent judge as he then was, said it has always been known that the day would come when the court has to give a decision on judicial independence. That day has come. Judicial independence is not to be found in what the courts merely say. It is to be found in what the courts actually do. In other words, it is to be found in what the courts decide. So that was one way of expressing the importance of judicial independence and how the courts approach this in putting this important concept or putting this important doctrine at the right place and also in the right manner. Right. So that is Bukhari in the case of Congo, the Congo case. What actually is judicial independence? I have said I'll make reference to Article 85. The elaboration there is the usual expression, free from any interference. Free from any interference. Let the judge or let the judges do their own job. Don't interfere. That's what the Basic Law has provided. However, it's generally considered that that is not quite enough. The focus of non-interference is only on the process of adjudication. Judges are human. They need more than just non-interference, but positive measures to put their mind at ease, so they don't have to worry. So what are these? Just being convenient it was convenient. Actually, the case. We are not saying that the case is of great importance, but it's convenient that in that case, in Valente and the Queen, it's back to 1985 already, but still, I think valid. That judges need job security. Judges need financial security, and there has to be institutional independence. Institutional independence. Most questions focus on 1 and 2, and which is quite a bit of common sense, isn't it? If you don't have job security, if you can be fired by some scrupulous or some person high in authority without any reason or without just indiscriminately, then how can you feel safe to act independently and even to the extent of going against the interest of people in power who can actually both hire and fire you? And we make reference to the Malaysian situation back in 1985, where Mahathir Mohamad did remove 6 judges. And there have been occasions in mainland China where, although not well publicized, but where it is clear and under the law that people's congresses at various levels can remove judges at any time. Now, of course, when looking at the example from China, from mainland China, one has to be very careful not to suggest that such power to remove judges has to be is not acceptable, because one thing that we have to be aware is that the constitutional system devised by the Chinese Constitution is very, very different from that of the common law or from that in Hong Kong. The system in China is a socialistic system with Chinese characteristics, and the system is people's representative system, and the judges are accountable to, or rather nowadays since the constitutional amendment in 2018, it is now first of all, the judges are under the supervision of the People's Congress, right? So it's entirely different, and alongside the judges, there is the institution of the procurator, which is not typical in the common law system. So when making reference to China, is only about this removal of judges, that it might make them worry and therefore not able to consider consider a matter against the interests of those who are in power. A case that in 2003 is something that very often was quoted to to illustrate this point. But coming back to Hong Kong, who chooses judges in Hong Kong? Who chooses judges in Hong Kong? Under the Basic Law, it is the power of the Chief Executive to appoint judges. And you say, wow, in that case, how can they be independent? Well, I mean, this actually preserves the previous system. It has always been the governor who appoints judges, and now Chief Executive, right? One thing is, it has the Chief Executive, so was the governor, will follow the advice of an independent commission called Judicial Officers Recommendation Commission. If there's no such recommendation, then there's no basis for the CE to appoint those judges. So there's a bit of check and balance there, and so that's how it works in Hong Kong. Of course, what then becomes important is who sits on this Judicial Officers Recommendation Committee. So Article 88, it says, judges of the courts of Hong Kong shall be appointed by the CE on the recommendation of an independent commission composed of local judges, persons from legal profession, and eminent persons from other sectors. Who are they? They are the Chief Justice, the Secretary for Justice, 2 serving judges, 1 barrister, 1 solicitor, 3 people not connected with the practice of law. And they are, we have the CE, CJ, we have SJ, Andrew Cheung. Of course, Andrew is, the Honorable Mr. Andrew Cheung will be our next Chief Justice. The Honorable Madam Kalau Zhu, Philip Dice, Stephen Hong, Anita Fong, Pamela Chan, and Professor Liu. And there is a secretary there. And the appointments have to be approved by the Legislative Council, and these are the appointment of the top judges. Only the judges of the Court of Final Appeal, the Chief Judge of High Court, must be approved by LegCo. Right, I think I'll stop here, and we'll carry on next time, and that will be next year, January the 5th. January the 5th will be it will be a Tuesday. So although it's next year, it's just a week to go. Yeah, that's right. We'll talk about next week. Any questions? Thank you, and do keep safe. I think, as far as if you're looking for tips for assignments, there's no model answer. From my experience of students of this class, they're usually very diligent, and the difficulty very often is the way they express their knowledge in English, which to some may be a challenge. I'm not quite sure what you mean, Stephanie. What is assessment tips? Waiting for. I'm not quite sure. I don't understand elephant fingers, Stephanie. But as I said, the menu that you have provides very useful material. But as I suggested, you can read the anti-mass law case, which I think because you know the facts well, that it may make it easier for you to understand. Right? The manual itself already contains a lot of information that you need for doing well, or for answering the question. What will make a good essay from not one that is not as good is actually the presentation, the structure, and the language. Try to avoid try to avoid grammaticals. Try to avoid grammaticals. Check your language. Check your English before you submit. And it's good to start early, but then, as I said, we are not getting to that point until later. So, best of luck and enjoy whatever is ahead of you before we meet again. Right? And stay warm. Keep yourself warm as well. I don't know, it may be a bit cool out there now. Okay, so good night and see you all. Happy New Year. Thank you.